Welcome to my series where I talk about interesting family law cases here in Australia. In this video, I'll be providing a summary of the 2019 Australian family law case of Wentworth and Wentworth. Trigger warning from the outset, this case involves sexual abuse allegations in relation to a minor. Noting, however, that the allegations were not substantiated and they were deemed not to be true. This is an interesting case because the court ordered a change of residence. The child had grown up living with its mother, and the court decided that due to the mother and her partner's conduct and the unacceptable risk of psychological harm in the mother's care, that the child would live with the father. The court also made orders for the father to have sole parental responsibility for the child. Now, parental responsibility doesn't relate to day-to-day care of a child or day-to-day small decision making. It relates to making major long-term decisions for children. Major long-term decisions relating to health. So, for example, should the child have a certain procedure, medical procedure? Should the child have an analysis in relation to a specific disability? Major long-term decisions relate to schooling, education, and also religious matters. It's a huge deal for the court to order a change of residence, so to remove a child from the primary attachment and to place it with the other parent due to risk concerns. It's a huge deal. So let's take a look at why the court made this decision from the beginning. The mother and father commenced living together in August 2012. They married in 2013 and they separated on 21st of July 2016. At the time of separation, they lived in a town that the court referred to as F-Town. There was one subject child, so one child of the relationship, and to protect the child's identity, the court refers to her as Child X, and Child X was born in 2014. At the time of the trial, the father was 30 years old. He worked full-time as a tradesman. He wasn't in a relationship and he lived with his parents in a town that the court referred to as Town G. The mother was 33 years old and engaged full-time in home duties. She lived with Mr. H, whom she commenced to live with in January of 2018, although the court noted that he'd been a significant part of her life and the child's life since November 2016. The child referred to Mr. H as Doddy. Mr. H was a technician and he has a child to a previous relationship. That child lived elsewhere with the mother and spent time with Mr. H during school holidays. Child X, the little girl, had always been primarily cared for by her mother. For a number of weeks before informing the father that she wanted to separate from him, the mother relocated with the child and didn't tell the father where she was for many weeks. The mother relocated to Town K, and notably at the time of the 2019 trial, she lived with Mr. H and Child X in Town K. Prior to moving to Town K, the mother had no connection with the area. Town K was 166 kilometres away from Town F, which is where she'd been living with the father and the child prior to separation. So yeah, it's important to note that the mother relocated with the child without the consent or knowledge of the father. The mother permitted the father to spend some time with the child in the presence of his parents in July of 2016, and the mother admits and contends that the visit went well and the child appeared to have a good time. On 7 February 2017, a final order was made by consent providing for the child to live with the mother and spend time with the father. Prior to the first visit contemplated by the order, the mother made a complaint to police because she said she felt threatened by Mr. Wentworth and the paternal grandparents' behaviour, and she sought a protection order against the father. The mother later withdrew her request days later after acknowledging to police that she didn't actually fear the father. Shortly prior to the commencement of the father's scheduled overnight time in July 2017, the mother made further allegations against the father and a temporary protection order was made for the protection of the child. So this is where the sexual abuse allegations came forward. The application was later withdrawn by the police in November 2017. The father recommenced proceedings on 4 July 2017 and the father's time was suspended on 26 July 2017 pending investigation of the mother's allegations. The father spent no time with the child until he saw her at the family report interviews on 11 November 2017. A further order for supervised fortnightly time was made on 18 December 2017 and the first visit occurred at B-Town Contact Centre on 10 February 2018. On 8 March 2018, the Department of Child Safety from Queensland informed the mother that her allegations against the father were not substantiated. On 20 July 2018, the father sought the mother's agreement to spend time with the child weekly rather than fortnightly, and the mother declined the request. On 13 and 27 October 2018, the child spent time with the father at the K-Town Contact Centre. It was intended that the time spent between the father and the child would thereby be increased to weekly. So 1 week in Town B and the other week in Town K. The paternal grandparents also attended the visit on 27 October 2018. The mother alleged that the time on 27 October 2018 had not been adequately supervised based on allegedly statements made by her child to her. The contact centre ultimately withdrew their services. The centre denied that anything untoward had occurred during supervised visits as alleged by the mother. Thereafter, the father continued to spend time with the child, supervised time with the child on a fortnightly basis at the Town B contact centre. Now let's turn to consider some of the allegations of sexual abuse made by the mother. From the outset, the judge stressed that they are very conscious of the difficulty in proving or disproving allegations of sexual abuse of a very young child, noting that sexual abuse of a child is the most heinous of crimes and quite rightly deserves the utmost condemnation. The judge went on to note that, unfortunately, allegations of this type are not infrequently made by litigants in this court in the context of bitter relationship breakdown, noting that it's all the more important to examine closely the evidence said to support the allegations and not be too ready to dismiss the evidence as baseless claims of a disgruntled wife or husband or partner, stating that context is very important, as is motivation. The judge noted that in this case, it is apparent that the mother regarded the marriage as an unhappy one. She regards the father as crass and overbearing. The mother objected to the father walking around the house naked or sitting in just boxer shorts at home. She contends that he was in the habit of grabbing her crotch despite her telling him not to, and contends that he frequently yelled at her. On one occasion, she became so exasperated by his behaviour that she punched him 3 times in the mouth in the presence of the child. Her actions caused the father injury and he was bleeding. Not surprisingly, given the mother's allegations, there were occasions where she also yelled at the father. The mother contends that there was an occasion when the father pushed her to the ground after he pushed open the bedroom door that she was standing behind. The judge noted that they are not satisfied that this incident occurred as described by the mother, or that it was an incident of family violence based on her evidence and cross-examination. On one occasion, the mother contends that the father aggressively brushed the child's teeth when she could not get the child to do so. The child fell and bumped her head, but the mother accepts that this was accidental. The judge found it curious that this incident finds its way into the mother's affidavit as an example of family violence. The judge noted that unfortunately, it seems the mother's dislike of the father and abhorrence for his allegedly crass behaviour towards her has influenced her interpretation of inconsequential behaviour on his part and others towards the child. A particularly troubling example of this propensity to view innocent behaviour as sinister was demonstrated by the mother's insistence that an entirely innocuous encounter between the child and the paternal aunt was inappropriate and suggestive of the aunt having been a victim of sexual abuse as a child. The incident was recorded by the paternal aunt and depicts her tickling the child as the child lies on her back and squeals with laughter. The mother maintained her concern about the video recording and stating that it was inappropriate after it was played during her evidence, noting that the video appeared to be a loving aunt having fun with her niece. The judge noted that on the mother's evidence, there has been virtually no opportunity for the father to have sexually abused the child. The mother's contention and evidence is that there were only 3 times prior to separation when the father spent alone time with the child. Many of her allegations about his inappropriate sexual conduct towards the child are said to have occurred in her presence. Since separation, the father's time with the child has been supervised by family members or agencies. On the one occasion that the paternal grandfather supervised the father's time with the child in June 2017, the father videoed the child going into a study and collecting animal skin rugs. This video was provided to the mother. The father says that he videoed the child as he thought her activities were cute. It seems that on this occasion, there may have been a minute where the paternal grandfather did not have the child and father in his sight. The mother contended that the father took this opportunity to do something to the child of a sexual nature, and she said that her suspicions were confirmed when she observed the child clinging to the father at changeover and the father's tearful expression. Despite the father's limited opportunity to engage in conduct of a sexual nature with the child, the mother maintains that the child's behaviour since separation, which the mother described as sexualised, quite possibly relates to what the father has done to the child during supervised visits. That was the mother's evidence and position. The judge noted that the sexualized behavior described by the mother has not been observed by anyone other than the mother and her partner, despite the fact that the child attends daycare, despite the fact that the child's time with the father has been supervised, The child has been interviewed by authorities on 4 occasions, and the child had been observed during interviews by family report writers on 3 occasions. The court noted that the circumstances of sexualized behavior caught on video by the mother appeared to have been staged, and in circumstances where the child is naked or semi-naked. Between the years 2016 and 2018, the mother made a number of complaints to police and the Department of Child Safety in Queensland and New South Wales about the father's behaviour towards the child and suggested that the child was at risk of sexual abuse from him. Despite the child's age, she was interviewed on 4 separate occasions in relation to the allegations of sexual harm. At least one of those interviews occurred at the mother's insistence and after the child had already been subjected to 2 previous interviews. The conclusion reached by the department in March 2018 was that the child has not disclosed any information throughout any of these interviews that have resulted in charges being laid against Mr. Wentworth, the father, or child safety being worried that the child is at risk of sexual harm by being in the care of Mr. Wentworth. Mr. Wentworth was assessed as being a willing and able parent, able to meet the care and protection and the needs of the child. A telephone interview between the mother and child safety officers recorded by the mother without the knowledge of the officers is interesting because the mother was informed that a decision had been made that the child is not at risk of harm, and they tried to explain that the child's behaviour may be completely unrelated to any of the abuse from the father and that the behaviour was actually age appropriate for the child. The child safety worker stating, and I quote, "And just because she's acting a bit weird or strange after contact doesn't mean something bad's happened. It just means that something's on her mind. She might miss dad, she might be missing you when she's with dad. There's lots of explanations for those kinds of behaviours and it doesn't always mean a bad thing." I think, Miss Wentworth, that you maybe need to do some education about what is normal and what is normal age-appropriate behaviour. I'm worried that you're confusing normal behaviours that we would see in a 3-year-old with sexualised behaviours, that maybe you're seeing that, it's actually what you want to see from that age group. And I think you need to do some education yourself, and there's a lot of agency in New South Wales who can do that course with you. That is significant. The family reporter, referred to as Ms. D, prepared 2 family reports in that matter, which the court said were of great assistance. She opined in the report that the child did not exhibit any signs or indications that would be consistent with her having experienced sexual harm during either of the family report sessions. She went on to note that the child was very comfortable with her father and exhibited a close father-daughter relationship and bond. The court noted that they're conscious, of course, that a close relationship does not of itself disprove sexual abuse. The mother produced video recordings of the child allegedly making the disclosures. The judge said, "I've listened to the recordings made by the mother of the child allegedly making the disclosures, and I share Ms. D, the family reporter's views. Like so many litigants who are intent on gathering evidence, the mother's actions are more damning of herself than anyone else. It was really quite challenging listening to this poor child becoming more and more hysterical as questions are fired at her. When the mother doesn't achieve an answer she is so clearly looking for example, when the child was asked who showed her the grocery game, which is a sexualized game, the mother says the child said the father played with her. When she asked who showed you the grocery game on recording and the child said, Mummy, the mother sternly punished the child for giving the wrong answer. The judge supported Ms. D, the family reporter's opinion that the mother appears to be continuing to approach the situation with the intention of seeking to validate her position in her ongoing pursuit of evidence gathering to support her allegations that the child has been and continues to be at risk of sexual abuse by Mr. Wentworth. And went on to say that Ms. Wentworth appears to be unable to process that the authorities charged with a mandate to assess and investigate child protection notifications have finalised their investigations as unfounded. So they've supported Mr. Wentworth and said he's not a risk and she can't process or accept it. The report writer said that if Ms. Wentworth is unable to make changes in her behaviour and attitude towards Mr. Wentworth, the child could emerge from this conflict with psychological problems which will extend into her ability to form meaningful relationships in future, stating that Ms. Wentworth appears to be undermining the child's love, attachment and relationships with Mr. Wentworth and the paternal grandparents. The family reporter stated its view that if Ms. Wentworth is not able to allow the child to develop an important and meaningful relationship with her father while in her care, then the court may need to consider a change of residence. The court noted that the mother sought to justify her allegations that the father was a risk to the child because of his alleged sexually inappropriate behaviour with the child prior to separation. In this context, the court did not accept the mother's evidence that she raised any concerns with the father about his behaviour with the child prior to separation. Specifically, they rejected the mother's allegation that in 2014, when the child was not 1 year old yet, She told the father to stop looking at the child's vagina. The mother said during cross-examination that she had observed a look on the father's face when he was fixated on the child's vagina. Despite the mother's stated concerns that the father's behaviour during the relationship, she contends in a statement provided to police on or about 18 June 2016, and I quote from the mother, "One weekend morning, I begged Mr. Wentworth to care for the child, something he mostly refuses to do and gets annoyed about whenever I ask for his help on the little things. I really just needed to sleep in a little longer that day." The court noted that they found that piece of evidence curious for two reasons. Firstly, if the mother really had suspicions that the father was sexually aroused by his baby daughter, why would she beg him to care for the daughter so she could sleep in? And secondly, the father's alleged lack of interest in the daughter seems inconsistent with the allegation that he was fixated upon her. The mother also claimed that prior to separation, she had observed the father adjusting himself so as to hide an erection. This allegation seems to relate somehow to the child, i.e. that the father was sexually aroused by the child. The mother says that she did not say anything to the father because she was scared. The judge noted that they did not believe her. Her history of communication with the father during the relationship was forthright. She frequently took him to task and set the rules. The judge also rejected the mother's evidence that she did not say anything for fear that he would be charged with a criminal offence. The mother also said that the father used to sit around in boxer shorts and made no attempt to hide his erection when the child was walking around naked or upon waking up in the morning. The judge said it was beggar's belief that the mother would permit her toddler to wander around naked if she thought the father was sexually aroused by the child. The mother also placed considerable weight on the child allegedly sucking on the father's nipple. The father agreed that the child would attempt to suck on his nipple at times, and he would respond something like, "There's no milk in there," and that this occurred at a time when the child was still being breastfed by the mother. The judge said that they rejected the suggestion by the mother that the father's conduct is suggestive of inappropriate sexual act. The mother also repeatedly alleged that the father asked the child to dry his penis with a towel. However, she later retracted this and said words to the effect of, "I don't remember his exact words," and whether he actually said the word penis or this bit or dry this area. The father denied the allegation completely. He denied all allegations of inappropriate conduct towards the child. The judge criticised the mother for missing pieces of information out when speaking to the police regarding the allegations. For example, in relation to the grocery game, she forgot to tell the police that she herself put the idea in the child's head. During family law proceedings, the mother told the family reporter that when she would see the daughter masturbating, she would say, "Let's go to the grocery store," so as to distract the daughter. So she was the one who put the whole idea and linking the grocery game and the grocery shop with that kind of conduct. In some of the recordings that the mother took of the child making the alleged disclosures, you can hear the mother whispering to the child, telling her what to say, so coaching her into saying certain things. Disturbingly, the mother staged situations involving the child being left naked and then questioned her and suggested answers. In one video, the little girl is putting a straw up her vagina. Instead of removing the straw, the mother gets her phone and starts recording. And her partner, Mr. H, was involved in the staged events. The judge stating that their behaviour deserves condemnation. During the trial, the mother withdrew her allegations at the end of her evidence. But the judge noted that nothing she said during her evidence led them to accept that there had been any change in her determination to interfere with the child's relationship with the father. Imagine being the father after she withdrew the allegations after all that time and not seeing your child for that time. In conclusion, the judge said that they had no confidence that the mother would stop her evidence-gathering behaviour if the child continued to live with her, and there were orders for a change of residence. So for the child to live with the father, spend no time with the mother for 6 weeks, spend supervised time with the mother, and then ultimately spend time with the mother alternate weekends. Do you believe the mother was attempting to alienate the child from the father? Or do you think she might have been projecting her past experiences or knowledge onto the child and the situation? Do you think this outcome was in the child's best interests? Change of residence cases require really strong evidence. I'm a family and divorce lawyer practicing in New South Wales, Australia. I hope you like this series video.